Yes, so good morning, everyone, and welcome to the first webinar in the AgriFutures Capacity Building Program for Emerging Industries. So today we're going to talk to you about how to incorporate an association. Now, this is what we'll be covering today. And we'll see how we go. I like to take just a quick 2-minute break in the middle. So to get started, in the Australian economy, there are generally 3 forms of ownership. So you've got your for-profit or commercial businesses, the government sector, and then we've got the words mission-driven. And this sector has lots of names, sometimes also called not-for-profit sector, for-purpose sector, and third sector, because there's 1, 2, and we're the third. So in the third sector is where associations sit. And as I mentioned, there's an association for everything. So some of the missions include professions, industries, communities, etc. Now, if you are a group of people that work in the same industry and you're thinking about setting up an association, or maybe there's an informal group that already exists, there are some benefits to incorporating. And what it means to incorporate is that you register with the government as a separate legal entity. And obviously this session is all about how you do that. But some of the advantages or the reasons why you would bother incorporating is that it does give you recognition by other organisations and by government. But the main one, I think, is the limiting of liability of the individuals involved. Yeah, so as I mentioned, the main benefit is the protection for the individuals involved, because if something goes wrong, it's the entity that is sued and not the individuals. And I'll get back to that, but some other benefits include credibility and legitimacy, ownership of assets and liabilities, easier to sign contracts, ease of succession, because you have different members at any point in time, as well as different board of directors, etc. A new independent entity is created and it is more than a gathering of interest. There's also clarity on tax arrangements. Okay, so if you are an informal group that currently exists and you are doing activities or projects, it is worth considering incorporating. For example, if there's money involved and a bank account needs to be opened, in whose name will that bank account be opened and who actually owns the funds? If a contract has to be signed, for example, if you're holding some sort of field day or event and there are suppliers involved, who will sign the contract? So if you're unincorporated, it will usually be an individual, the volunteer. And so that volunteer that signs the contract is legally liable for fulfilling the entitlements of that contract. And then, in the very unlikely event that's, for example, if someone hurt themselves at that event, who will they sue? The individuals involved, because there's actually no entity to sue. The note there is that limited liability will not apply to protect individuals if you are a director or an officer of the incorporated group and you breach what's called director's duties, which we'll talk very briefly about later on. Okay. But generally, the main advantage is that it does limit the liability of the individuals involved with that group. And if you are considering incorporating, I guess the 2 main questions to consider, well, there's 3. One is, why do we want to set up an association and what do we want to achieve? Is there an existing organisation that could do the work that we want to do? And then the second is volunteers. So do we have enough people to keep it going? And specifically to ensure that the compliance and reporting obligations are met, which we will also talk about. And the third is funding. Where will we get the money to do things and at the minimum to pay the compliance fees, the annual compliance fees and the costs with holding the mandatory meetings. So the alternatives to incorporating is you remain an unincorporated group. And some of the advantages to that is that the group then can remain informal. It doesn't have to hold meetings at all. And if it does, it doesn't have to be in a specific format. It doesn't need to register with the government. So there's no disclosure to government or the public about its members or its financial situation, and no fees or reporting. Or you can become part of an existing association. Once you decide that you do want to incorporate, there are two main ways to legally incorporate an association. The first is as what's called a company limited by guarantee. And this is regulated by the Corporations Act, which is a Commonwealth legislation. And the regulator then would be ASIC. The second is to incorporate as an incorporated association under one of the state or territory associations incorporation acts. And there's one in each state and territory. Now, some organisations are special in that they've been set up by Royal Charter or their own Act of Parliament, but they're a smaller group. Once you have legally incorporated, if you exist for a charitable purpose, you can register as a charity with the ACNC, which is the Australian Charities and Not-for-Profits Commission. And just to give you an idea about numbers, we think there's around 25,000 companies limited by guarantee, and incorporated associations, there's around 150,000 of those. And the charities, I think the ACNC has 55,000 charities on their register at the moment. Okay. So in terms of incorporated associations, a few years ago, we called each state regulator. So they're listed, there's 8 of them, and they all have different names. And we asked them how many incorporated associations are on your register. So these are roughly the numbers. So Vic, New South Wales, Queensland have the most, followed by WA, SA, and then smaller amounts in Tas, ACT, and NT. So this is just a table summarising the acts. Now, we also mentioned unions and registered organisations, but don't worry about that. We don't work much with unions, although some of our members are unions or registered organisations. So we're more concerned with the top 2 rows. Now, if you set up as a company limited by guarantee under the Corporations Act, you have to have the word limited after your name. Generally, there are some exceptions. And then if you set up under the Association Incorporation Act of a certain state or territory, you have to have the words Inc. or incorporated after your name. Now, the word limited or I should say the word guarantee. So what does it mean to be a company limited by guarantee? The guarantee refers to a nominal amount that each member agrees to contribute should the organisation wind up. And when I say nominal, it's usually $1, and I've seen some as high as $100, but it's a very low amount. In terms of incorporated associations, the liability of members is usually specified in the Constitution, and it's capped at whatever the annual membership fee is. Okay, now I just want to clarify some terminology before I move on to the next few slides, because we're going to be talking a lot about these particular words. I will refer to a constitution, which is the governing document for any association. And there are various names for this particular document. Some associations call it rules, some call it memorandum and articles of association, which is actually a very outdated term. So when we do a constitution review and we see that, we know that the document hasn't been updated for a number of years. There's a governing body. We usually refer to it as a board, and the people on that board as directors. But again, some associations call it a council, some call it a committee, some call it a management committee. And certainly in the state and territory acts, they usually refer to committee or management committee. Associations have members, so that's straightforward. And then those that are rich enough will have a senior staff person, usually called the CEO. Now, some general principles about incorporated association versus company limited by guarantee. So the state acts are aimed at this, state or local or regional organizations. So if your activities are going to be limited to that state, or you're a fairly small entity, then usually incorporating as an incorporated association is okay. Now, associations that work beyond that state would need to apply for an ARBN, which is an Australian registered business number administered by ASIC. So technically, if you are an incorporated association, you should only be operating within that state that you incorporated. And then to operate beyond the state, you apply for an ARBN. Companies limited by guarantee under the Corporations Act, there is a bigger body of law that relates to this legislation because it's more well known and there's more organisations under that legislation. There's a perception that it has higher compliance standards and a more serious image. However, the principles of governance apply regardless of whether it's an incorporated association or a company limited by guarantee. And what we've seen over the years is that the state acts are being updated to include duties of committee members or directors that are consistent or similar to the duties under the Corporations Act. So we are seeing emerging of the jurisdictions over time. Now, how to choose a legal structure? Okay, so these are some of the questions to be considered when choosing the most appropriate legal structure. The first is, where will we carry on business? So as I mentioned, incorporated associations can only technically carry on business in the state that they're registered in. But if you're intending to operate around Australia, then potentially the better structure will be the company limited by guarantee. The second is affordability of application and annual fees. So ASIC, being the regulator of companies limited by guarantee, their fees are generally more expensive than the state regulators, and we'll give you some examples in the next few slides. And also they charge penalty fees for late lodgement. So if you're late, there may be penalty fees of a few $100s. Whereas some of the state regulators do not charge late fees, or if they do, they're relatively lower than the ASIC fees. The third is, will the association register as a charity? Now, why this is relevant is that because if you register as a charity, then the ACNC becomes your main regulator, but there may be dual reporting depending on which state you register under. And if you intend to register as a charity, the company limited by guarantee structure is usually better because many of the provisions in the Corporations Act are switched off for charities, and we won't go into that today. And there's no reporting to ASIC, so all the reporting will be done to the ACNC. And the ACNC, I would describe them as they're a very educative regulator rather than punitive. So my understanding is that they do not charge fees. I think they might charge late fees, but they do not charge fees for lodgement of reports and things. And they try to be helpful to charities. And they have a great website with lots of resources and guides. But whether your organisation qualifies to be a charity or that's a separate issue, and you have to exist for one of the 12 charitable purposes under the law. Happy to have a separate conversation about that. Now, ongoing reporting requirements. So there are different annual reporting requirements depending on the jurisdiction. And I'm going to give you some examples. And the joys of working in a federation, the terminology is not consistent, and even the tiers they use sometimes conflict with each other, but we'll go through that. And then there are some other matters for consideration. Okay, so in terms of regulatory and compliance requirements, you know, there will be annual reporting to regulators generally, as well as audit and review requirements of your financial reports. And then there will be costs of holding meetings. So what I mean by that is there will be costs associated with holding board meetings, for example. Although with COVID, what we've seen is, you know, everyone's doing Zoom meetings. So the travel costs are minimised and accommodation, etc. You also have to hold what's called an AGM, an annual general meeting, and there might be costs associated with that if you hold a physical AGM. So in terms of reporting to the regulators, these are, we haven't looked, I mean, we know the fees for each of the 9 jurisdictions, but we won't present it in this presentation. But obviously, if you have questions about a particular jurisdiction, do contact us after the webinar. So just to give you a overall, a big picture idea of the types of fees. So ASIC, which is the last row, you'll see the application for incorporation is $400. The annual fees are $1,200. So that's fairly high compared to the state regulators. So we just chose the 4 or 5 biggest states. They range from, you know, $37 to $250-ish. So it's a relatively cheaper regulatory framework. And also, as I mentioned, consider late fees. And there may be fees for lodging of changes. So for example, when you change a constitution, or, you know, not as common is if you change your name, then you may have to pay a fee when you lodge that change. Now, I think, Anshua, have we got any questions? I'll just pause there in case there are.
Yes, Kathy, there is one question on fees. If ACNC registered, then do we require to pay annual ASIC fee?
Yeah, so that's right. So if you register with the ACNC, definitely if you're a company limited by guarantee, you won't have to pay the annual fee. Now, if it's an incorporated association under one of the states, you may have to pay a fee depending on the jurisdiction. But I think what's happening is that there are streamlining arrangements between the ACNC and the state regulators. So generally, if you're ACNC registered, no fees.
Thanks. There is another question, Kathy. Why there is a range for application fee in Victoria?
Now, Anshul, when you looked this up, was it to do with the tier?
Yeah, and it's also to do with own rules and the model rules. So if we use own rules, we have a lesser fee, application fee. If it's a model rule, the lesser fees, and if we have own rules, there is a higher fee benchmark.
Great, thank you.
And for annual fee, it's a tier structure. So tier 1, 2, 3, depending on the revenue that the company earns. The higher the revenue, the higher the fees.
Great, thank you. Yes, and we're going to talk a little bit about the tiers of fees now.
Yes, Thanks,
Yes.
Kathy. Sorry, another question is
Yes.
here. What are the options and pros and cons of other options besides becoming an association?
As in, okay, well, there are, like, for example, there are cooperatives, which is less common. The most common structure is incorporated association or company limited by guarantee. So for most associations, that would be the structure that they choose. And then there are also, I understand you can also be a charity if you're proprietary limited, which is extremely uncommon. Yeah.
Yeah, and there's one comment from Bernard. There are no annual reporting requirements or fees in SA for associations with turnover less than $500,000.
Great. Thank you.
Yeah.
Thank you for clarifying that, Ben. Yes. Okay. All right. So financial reporting tiers for companies limited by guarantee. Now, a small company limited by guarantee, tier 1, are those with revenue less than $250,000. So small CLGs do not have to prepare a financial report or have it audited unless directed by a member or ASIC. And then there's 2 more tiers after that. So 250 to 1 million and those over 1 million. And those larger ones do have to prepare a financial report. The middle tier has to have it reviewed rather than audited. And then the large tier 3, which is the large company limited by guarantee, has to have it audited. Now, the difference between review and audited is a review is, I guess, a lower level of assurance than a full audit, and also it costs less. Okay. Now, small CLGs also do not have to lodge their financial statements to ASIC, but the other tiers do within 4 months of the end of the financial year. Okay. Now, in New South Wales, their tier 1 is large rather than small, and they consider large as total revenue more than 250,000 or current assets more than $500,000. So if you're a tier 1 large association in New South Wales, your statements have to be audited. And then if you're small, then there's no audit requirement. So they have 2 tiers in New South Wales. And in Vic, they have 3 tiers. So tier 1, less than 250,000. So their tiers are similar to the ASIC tiers, and also the requirements about whether it should be reviewed or audited. Okay, and again, each state and territory has different reporting tiers, and happy to give you that information. And SA, thank you, Bernard. I think they have 2 tiers: prescribed association, which is $500,000 is the threshold, I believe.
Kathy, can I jump in there? It's Gary here.
Of course, yes.
We're looking at set up an association to run a conference that's held every 3 years. So we would only really get any revenue once every 3 years. So would you be able to average that out over the whole term?
So it would be the reporting for the financial year, that financial year, if that makes sense, yeah.
So it might be 1 in 3 years you'd have to do this reporting.
Yeah, that's right.
Great, thanks.
Yeah. Okay. Now, some other matters for consideration. The location of what's called the public officer or the secretary. Some of the state and territory acts require that the association have a public officer. For example, in New South Wales and ACT, you have to have a public officer, and that public officer has to reside in that state. So if it's in New South Wales, your public officer has to be a New South Wales resident, and so on for the ACT. Now, companies limited by guarantee, you have to have a company secretary, but they can live anywhere. And the Victorian Act also requires a secretary, but again, they've removed the requirement for the secretary to be a Victorian resident, which is helpful for those associations that want to set up as an incorporated association. Because what we see sometimes is as associations mature and evolve, for example, they might have set up in the ACT, but they now no longer have any volunteers in the ACT who can act as a public officer. So that can be a bit of an issue. The number of members is another consideration. So companies limited by guarantee, the minimum number is 1. In New South Wales, Vic, WA, ACT, the minimum number of members is 5. In Queensland, it's 7. And interestingly, in South Australia, you do not even need any members, although I'm not sure how you're an association without the membership, but there you go. So that is a consideration. Now, directors' duties. So as I mentioned, in the various legislation, there are prescribed legal duties of directors or people on the committee. And in the third webinar, we'll talk a little bit more about what those duties are, but it is important to understand what those duties are depending on the legislation that you incorporate under and the potential penalties that are involved. So because the Corporations Act, covers not just not-for-profits, but the commercial sector, the potential maximum penalties are obviously higher than the state legislation. Constitution. So the state acts provide what's called model rules or model constitution. There's also replaceable rules in the Corporations Act, but they're not really appropriate for associations. So they can be helpful in terms of the development of the constitution. But also what needs to be considered is that with the state acts, they're actually quite prescriptive about what needs to be in your constitution, whereas the Corporations Act leaves it up to the association to largely determine what they want in their constitution. Also with these state acts, there's usually a provision that any changes that you make have to be approved by the regulator before they come into effect. Whereas ASIC does not approve constitutional changes, they just require you to lodge the change. But once the membership approves a change, then it can come into effect. And with the prescriptive matters, for example, there are some quirks in some of the state acts, like the Queensland Act mandates the role of treasurer, whereas none of the other acts do. Also, the Queensland Act requires all board members to be elected at an AGM, which I think is quite rigid because some associations don't have that election process, or they might have an appointment process. So there are quirks in some of the state acts. The Tasmanian Act, I think, is a 1960s act and has not been updated since then. So it hasn't quite caught up with current technology and business practice, for example. But again, happy to have that conversation if you want to know more about a particular jurisdiction. Now, the rights of members. In the Corporations Act, the rights of members is much clearer because the state acts generally leave it up to whatever is in the Constitution. And when we say rights of members, we mean, for example, I've given some examples, the right to appoint a proxy at a general meeting, the right to call a general meeting. So under the Corporations Act, it is required that if 5% of the membership requests a general meeting, then it needs to be held. Public access to information. Now, if you go on the ACNC or the ASIC database, you can look up any association and you can, for example, the ACNC information is all free. So on the ACNC, you can check who the directors are, the constitution, the financial statements, etc. The ASIC database is public, but there is a small fee attached to look up that information, but it is available. Whereas the state acts, some don't even have a register of their members as a public database. Some do, which is better than nothing. But certainly to get information about an association is pretty difficult. Perception and culture. So as I mentioned before, because companies are more widely recognised and understood There is a perception that ASIC is a more vigilant regulator, and there's a high level of compliance. And related to point 8, so there is a way to convert an incorporated association to being a company limited by guarantee. When that happens, what we've heard anecdotally is that when dealing with external parties, such as funders or governments, you have a more serious image when you say you're a company limited by guarantee. And also psychologically for members of the board or the committee, there's something about being a board director as opposed to a management committee member that raises the level of governance. Anshu, any questions coming through? Yes, Gary.
Sorry, Gary.
Sorry. What was I going to ask? But when you say a board, I mean, a board sort of, at least in a company, there's a whole lot of responsibilities involved in that obviously need specialist training as well. But in these sorts of boards, they're a bit of a different level, are they?
Well, yeah, so that's a good question, which is related to directors' duties. Look, the many of the state acts have actually been updated over the years, and they've incorporated very similar duties to what's in the Corporations Act. So, for example, there's a duty to act with due care and diligence. That's in a lot of the acts now. So it doesn't really matter which act you incorporate under, those duties do apply. Also, regardless of the way you're incorporated, the common law, which is the judge-made or the case-made law, the duties under common law still applies. Does that answer your question, Gary? Yeah.
Kathy, we have another question coming from Dawn. Are there any statistics on which associations are also charities in Australia?
Yeah, so I don't know about which associations, but I know the ACNC has around 55,000 charities on their register. Some of them, however, are, they also have what are they called, like trust funds and churches. But I guess there's probably a way to extrapolate that data. If you go onto the ACNC and exclude those categories, the remaining are probably associations.
There are no more questions for
Great.
us.
Thanks, Anshul. Okay. All right. Now, with associations, typically these are the people involved in the roles that they play. So you have the membership who, subject to the Constitution, usually elect the board of directors, sometimes called a council or committee, as I mentioned. The board of directors then appoint the CEO when affordable, and the CEO appoints the staff. Now, to support the board, there are usually subcommittees, set up to do specific work. And many associations also have special interest groups, by technical areas or specialty areas, etc. Now, with members, their role is they can choose to join or not, and if they join, they pay the subscription. They can elect and remove directors. They can change the constitution, and they appoint the auditor if required. So the members' role, while important day to day in a governance capacity, their role is limited, but they have ultimate reserve powers in that if they're not happy with what the board is doing, they can either not re-elect those directors, or in extreme circumstances, they can call a general meeting to remove a director or the directors. And the Constitution being the governing document, only the members can change the Constitution. Now, the board of directors or the council or committee, they have ultimate responsibility for the organisation. So they're responsible for governance, strategy, complying with their legal duties, and reporting to the members usually once a year at the AGM. Okay, so steps to incorporate. Now, again, depending on the jurisdiction, the order might be slightly different, or there might be some additional steps. But generally, the process is this. You choose a name for the organisation. You go in the ASIC database to check if the name is available. You recruit an initial board or committee to get it going, develop the constitution, get consent from the initial people involved, so directors, public officer and members, lodge application to incorporate with the relevant regulator, and then get an ABN, Australian business number. Now, the step that involves the most work, and I think the most important, is number 3. So the development of the constitution. The constitution, being the governing document, sets the foundations for the governance structure and how the organisation is going to work and be run. Okay. And in the next few slides, we are going to talk more about constitutions because it is such an important document. But I might just take a 2-minute break before we do that, and also take any questions at this point. Anshu, anything coming through?
Yes, Kathy, we have one from Olivia. She's asking, can directors also vote to remove a director? And what about a CEO?
Okay, I'll deal with the easy question first. So yes, boards can remove CEOs. I've heard directors tell me the board has 2 important jobs. One is the hiring of the CEO, and the second is the firing of the CEO. Now, in terms of whether directors can remove other directors, that is a harder question to answer because it depends on the jurisdiction. Under the Corporations Act, the board cannot remove a director. And I guess under the state acts, generally it would be up to the constitution. But actually we would agree with the principle behind the Corporations Act, because directors are appointed or elected by the membership. It should be up to them to remove directors. So if the board is not happy with a particular individual, and sometimes that happens, but sometimes it might be that that particular individual is not agreeing with maybe the rest of the board is trying to do the wrong thing. And so they shouldn't have that right to remove that director just because he's not or she's not in agreement with what the board is doing. So yeah, a less clear-cut answer depending on the legislation.
There's one coming from Michael. In many cases, a board can add a director outside of members.
That will depend on the constitution, yes. So if the constitution allows that, which we will talk about, yes, you can do that, yeah. Except in Queensland, where all directors have to be elected by the membership. So I guess potentially they could still be a non-member, but they still have to be put up to the membership for approval. All right, so let's spend a bit of time talking about constitutions. Obviously, the legislation and the common law overrides the constitution, but the constitution is the mini law for the association, and legally it is a contract between the association and the members. It should be clear and relevant, not ambiguous and operational. So, for example, do not include, actual membership fee amounts or a list of member benefits or services. It needs to include the required tax rules to be eligible for tax benefits, and we'll tell you more about that. The law specifies how the constitution can be changed by the members, and usually that's by the members passing what's called a special resolution, which is a 75% majority of votes cast at a general meeting once quorum is reached. We've seen some constitutions that have not been drafted that well, and they've defined a special resolution as 75% of the membership. And so, if you've got 500 members, 75% of 500 is quite a high number to get. And if you're trying to change that in the constitution, you've got to get past that hurdle first. The general trend or theme that we're seeing with constitutions is that they should enable you to do things. So they shouldn't restrict you from doing the things that you want to do. And they can be a hindrance if, for example, it is ambiguous, so no one knows what it means, or it sets up cumbersome governance structures, or it's really prescriptive about certain things unnecessarily. So that's why they need to be developed. Some time and thought needs to be put into their development at the beginning to save a lot of headaches later on. Now, point 5, constitutions. I mean, once they're drafted, they're not set in stone forever. So they should be reviewed every few years to ensure, well, that it's compliant with the law at the time, that it's actually consistent with what's happening in practice. Sometimes if you let constitutions get out of date, what we've seen is that they get ignored and then they're not being complied with anyway because it doesn't reflect what's actually happening with the association's practice at the time. So in terms of what's in the constitution, so 5 main areas. The objects, the membership, the board, there's a section about general meetings, and then other mandated matters. So with the objects, it's a weird term, but basically this is the clause that outlines the purposes or the legal reason for why the association is being established. Okay, so this is really important because it does influence taxation status. And if you're clear on what the purpose is, then you can develop a plan that shows how you're going to achieve that purpose. If you're too broad, it can be hard to decide who you stand for. And so that, again, sometimes organizations do revise their purposes and, might expand the scope of what they're doing, or they might refine the scope of what they're doing. Okay, so the other 4 matters, I have some slides on that. With membership, it should be clear who can be a member, and more importantly, who gets a vote. So when we do constitution reviews, this is always one of the things we look at. Is it clear who is a voting member? This can be an issue if it's not clear, because, for example, if later on you want to change the constitution, how will you determine who gets to vote to pass that special resolution? Okay. Usually constitutions would include disciplinary procedures, so how to expel, the process required to expel a member, which is quite an extreme thing to do, but sometimes it has to happen. And a register of members is required. So what we mean by that is legally you have to keep a list of who your members are. And remember that members ultimately control who's on the board, so beware of branch stacking, which is related to point 1 about who can be a member. We always recommend that there be some broad parameters about eligibility criteria. Okay, so this is one way to prevent branch stacking. We've worked with a couple of organizations that either had no criteria or vague or loose criteria, and through that process some people were able to sign up their friends or their colleagues with the view of taking over the board. So it sounds quite outrageous, but it's we do see it happen from time to time. And there's a principle that people or organizations cannot be deemed to be members. So what we mean by this is, this usually happens in what we call a federation of associations. So if there's an association in each state and territory for the same cause, and there might also be a national association for that cause, the state constitution might say, if you become a member of us, you automatically become a member of the national organization. So you cannot deem, and we do not agree with that, because, and the principle behind that is, if I join one association, it doesn't necessarily mean I want to be a member of another organization. So if I join my professional society, an extreme example would be okay, by joining this society, you are now a member of some, you know, political association or anti-environmental association. So membership in constitutions is very important, especially for associations. Okay. Now, constitutions also include provisions regarding general meetings. A general meeting is a formal meeting of the members. Usually there's only one general meeting a year, which is the AGM, annual general meeting. And generally, again, depending on the legislation or jurisdiction, the AGM must be held within 5 to 6 months of the end of the financial year. When sometimes we see associations confuse a general meeting with just a, you know, regular member forum or a member gathering of some sort. So a general meeting is a formal meeting. It's a legal meeting of the membership. And really, there should only be one general meeting, the AGM. And sometimes you might have to hold a special general meeting if, for example, you want to get constitutional changes approved in between AGMs. So the Constitution would have clauses around the procedure and the voting process at a general meeting. Use of technology. This is really important, and especially last year with COVID, we saw many associations have constitutions that didn't provide for the use of technology, and or worse, forbid the use of technology. They hadn't been updated for a few years, and so they've had to update their constitutions to keep up with that. Proxies. A proxy, basically, if a member can't attend a general meeting in person, they might be able to appoint a proxy to attend in their place. And so the rules around proxies and appointment of proxies are in the Constitution. And as I mentioned, under the Corporations Act, for example, a member has a right to appoint a proxy, whereas under the state acts, they usually leave it up to the Constitution, and some constitutions do not allow proxies and some do, and we're certainly fans of proxies. If a member can't attend, they shouldn't be disadvantaged from participating. Whether the chair has a casting vote or not. What we mean by a casting vote is if the votes are equal, does the chair, get the final vote? And our recommendation is no. So if the vote is tied, the motion is a failed motion, so no resolution is passed. This is what we would recommend the Constitution state. Okay, Anshu, any questions so far? Okay. All right, now.
Oops, sorry, I was on mute, Kathy.
Okay, yeah.
We don't have a question. We have a comment from Bernard. He says, we have associations as members.
Yes.
Yes.
Okay. Yep.
Yeah, when we said that in a federation, there should not be deemed members, I suppose Bernard said that it's possible to have association as members.
Oh, yes. It's and members do not have to be individuals. Members can be other institutions, other organizations, government departments. Again, that's all stipulated in the Constitution about who or what can be a member.
Okay, right. Thanks.
Okay, thank you. All right, now another important component of the Constitution is the board. Okay, and specifically size and composition. So our research amongst our membership network, the average association board size is 9 directors. And we think that's about right. From time to time, we meet boards that have maybe 20-something directors, and we think that's too large. And it comes down to, we're not fixated on the number, but you need a group that is small enough that decisions can be made, and that there is engagement of each director. So if you're on a large board, for example, it's easier to miss meetings because your absence is not as noticeable. So you get a more engaged board with a smaller group. But at the same time, you need a board that's large enough so that there are enough people to do the work that's required, especially for volunteer associations, and that you have the right range of perspectives and skills, etc., that you need. Now, how someone becomes a board member or a director, this process would be outlined in the Constitution. And so usually there's an election or an appointment process. And if there's an election process, we suggest the ballot be held before the AGM with no nominations to come from the floor of the AGM. And some of the state model rules, draft it so that the ballot is at the AGM and nominations can come from the floor. So if you plan to adopt the models, we suggest you look at that and change that. The reason for that is it's easier to conduct a ballot before the AGM because I've been to some AGMs where they do have to conduct a ballot and they sort of have to stop and do the administration of it. And also what we saw last year with Zoom is that it was hard to conduct, like for example, a secret ballot on Zoom. And so when you do the ballot before the AGM, you can announce the results at the AGM. No nominations to come from the floor of the AGM. The reason we suggest this is that you don't want any surprises. So, any future board members should be known beforehand and due diligence can be conducted. Now, the Constitution will also state director eligibility, so who can be a director. For most associations, that might be you have to be a voting member. Okay, that's probably the most common criteria. In other associations, they have more specific criteria. Now, some national associations and charities have directors from every state and territory. This is a common model for national associations. And then other associations elect their directors from the membership at large. So they have general elections, and if you get the most votes, you get on the board regardless of where you live. If you have members from the same background, having an independent director may be appropriate. What we mean by that is, especially for associations that, for example, represent a certain profession, all the members will be, a teacher, or they'll come from the same industry. And so sometimes they update their constitutions to allow the appointment of independent directors. They have various names, sometimes called external directors, community directors, non-member directors, but it's basically a director that may or may not be, usually not from the membership, and appointed by the board. And so one or two positions for independent directors is okay, but we still believe that the majority of the directors should be from the membership. And 8, so our recommendation is no alternate directors. So what we mean by that is some constitutions allow directors to send an alternate if they can't attend a certain meeting. And we do not recommend that. If you can't attend a meeting, you miss the meeting. And the alternate, is not an agent of the appointing director. So they, come with their own risks and liabilities. And if at any given board meeting, there's always different people there, that can be quite disruptive to the normal functioning of a board.
Kathy, can we have some questions here?
Yes, yeah, sure. Yes.
Thanks. So the first is from Tim. Why do we recommend that chair does not have a casting vote at AGM?
Yes. So again, this is not mandated, our recommendation. And the reason we recommend that is, 1, it sometimes puts the chair in a difficult position. And 2, we do not think that a certain individual should have more votes than another member. So if it's tied, it means it hasn't reached the requisite majority. And so it's not approved. That's our view anyway, but happy to hear any counter views.
Thanks. Then we have a comment from Michael. We have individuals and organizations as members and need to take care that the individual representing a company member is not also an individual member, although technically, okay, we understand.
Okay. Was that a question or?
That was just a comment.
Okay, thank you. Yes.
And then we have one question from Linda. Not mandatory, but how beneficial is it for directors to be AICD qualified?
Look, if you have the funds to get AICD training, go for it. I've done the course, the 5-day course, and I learned a lot. It is, I would say, more focused towards commercial, the commercial sector, but certainly there are great benefits to doing the AICD course. But if you're just starting out, maybe a shorter course is fine, or one geared towards not-for-profits. Yeah.
That's it.
Can I ask another question, Kathy?
Yes.
Just when we're looking at setting up an organisation, how do you get the board going when you don't really have the membership base there yet?
Yeah, get the board. Yeah, well, you need the minimum number of board members depending on the legislation. So let's say the minimum is 3. So you've got to recruit 3 volunteers, and then those 3 just need to meet and get the activities going. And one of the first things on the agenda might be recruit members. Yeah.
Okay. Yeah. So then you recruit your members. Then you would follow that up with a formal AGM to actually, I'm thinking you need a board to start things rolling, but that may not be the board that runs the organisation in the longer term.
Yeah, so that's right. So I guess before you incorporate, you need people to lodge the application to get it started. And as I mentioned, there is a minimum number of members for some jurisdictions. So for example, in Queensland, you need a minimum of 7. So you need to recruit 7 people to get it started. And then once you incorporate, you would meet formally as a board, with the agenda and, minutes, etc. And then you just decide what you want the association to do going forward.
So what's the minimum number of members for the, what was it, company CLG?
1.
1, okay.
Yes, but you need, for CLG, you need 3 directors. Anshu, is that correct? So Anshu will correct me if I'm wrong. But
yes.
So it's 1 member, but 3 directors.
Great, thanks.
Yeah.
And we have one comment from Bernard who says all our members are also our board members.
Yes, and that's fine. So board members are usually members, but if the comment is about the only members are the board members, when you're starting out, that might be okay, but over time, hopefully the membership group grows larger than the board, so that the board is accountable to the membership. Any more questions?
That's all we have, Kathy.
Great, thank you, everyone.
Oh, sorry.
Yes.
Just one more.
Yes.
Can you please clarify what is the difference between a board member and an independent director?
Yes. So the independent director is a board member. It's just terminology. What we mean by that is, for associations, usually the board is comprised of members. So, the members vote for other members to be on the board. And sometimes they update their constitutions to allow for non-members to also be on the board. And then so they might call it an independent director, or they might call an external director or non-member director. So they have various names, but it means a director that hasn't been, that's not a member and hasn't been elected by the membership.
Thanks, Kathy.
Hailey from Victoria. I've got a question.
Yes.
In some organizations, I noticed that the CEO also a member of the board.
Yes.
So is that possible to be a CEO at the same time a board member?
Yes, that is possible depending on the constitution, but our recommendation is not to have the CEO as a board member. And actually over 90% of associations would not have the CEO as a board member. The reason for that is the CEO is actually accountable and reports to the board. so they shouldn't be part of the board. However, that doesn't preclude the CEO from attending board meetings, and most CEOs would attend every board meeting, and some CEOs are also the company secretary, so they'd attend the board meetings anyway. But generally, we do not recommend that the CEO is a member of the board. Okay. Anshul?
Yep. We have got another question from Tori.
Yes.
Can you define the relationship of a charter and a constitution?
A charter?
Yes, a
Okay.
charter and a constitution.
If I'm understanding correctly, and please speak up if I'm not, the charter, as in a board charter or a governance charter, would usually be a separate document to the constitution, and it's changeable by the board. It's like an internal board policy, and it might go into a little bit more detail about how the board operates. So for example, in our template board charter, there's, you know, the role of the president. So usually that would not be outlined in the constitution, but the board charter can be a bit more prescriptive about what the president actually does. And if you have a CEO, you know, there'd be the role of the CEO versus the role of the board. Also in the board charter, you might have things like your policy around minutes or how agendas are put together, the timing of them, expected director behaviour at board meetings. So that's not something that would be in the constitution. And it's like, I guess, the operations manual for the board. So if by charter that's what you mean, I hope that clarifies the two documents.
Yeah, I think that should be okay. And I think we have at the top, Kathy, the legislation, which lays out the broadest parameters. The constitution cannot be inconsistent with the legislation. So the second level is constitution, which gives us more defined things. And then we have a subset as a charter, which cannot be inconsistent with the constitution and the legislation.
Yeah.
So the charter is a subset of the constitution and more prescriptive.
Yes.
Yeah, so we have got a few more questions by now.
Okay.
From Olivia, what is the minimum number of directors on a board required in Victoria and ACT?
Okay. Can Anshul, you look that up and then just type it?
Yes, I'll have to
Sorry,
check because
I
there are
don't
different
know the
numbers.
exact numbers for those two particular states, but we'll get back to you. It's easier to find the information. Yeah.
Okay, and then we have got thank you.
That's it? Okay, great.
Yes.
All right. All right, so still on the board. Now, the Constitution should specify the terms of office. So if they are elected, you know, how long are they elected for? And commonly, associations would have 2-year or 3-year terms, but directors may be re-elected for consecutive terms up to a maximum term limit, which is usually long, although some constitutions it's only 2 terms, and we've seen others that go up to 8-10 years. So you have to strike a balance between the refreshing of the board and the, you know, continuity and retention of knowledge. And also you have to keep in mind how big is the pool of potential directors out there. So if you've only got 20 people in your community, then maybe you don't need term limits, and longer terms may be better. And we also suggest, where possible, to stagger the terms of office. So what we mean by that is the Senate style election. So if it's 2-year terms and you have a board of 8, every year 4 directors would retire and renominate. And so you have annual elections, but only half the board would spill every year. Okay. Now, and some other matters about the board. So the Constitution would address office bearer roles. What we mean by an office bearer is it's a director with a title. And the most common office bearers are treasurer, president, vice president, or they might be called chair and vice chair or deputy chair. And some constitutions also mention a treasurer and a secretary, which is fine when you're starting out, but especially if you do get staff, then we do not recommend honorary treasurers or honorary secretaries, because those jobs could be done by the paid staff or secretariat. So with the office bearer roles, the Constitution will need to outline how you get appointed to those roles. So is the president elected by the membership, or are they appointed by the board from amongst their number? So we would recommend the latter, and our statistics show that's around 70% of organisations would do it that way. Whether directors are paid. So if you want to pay your directors, this needs to be permitted in the Constitution. And for most volunteer organisations, there's a prohibition on payment to directors. And then, you know, if you get richer, you might think about changing that. Board meetings and voting rights. So just a few things about that. We recommend no proxy voting at board meetings, which is different to a general meeting. So as I said, if you're a director and you can't attend a board meeting, then you can't attend the board meeting. All directors should have a vote. So you shouldn't have any non-voting directors. If you're a director on the board, then you should have a vote in order to properly fulfill your legal duties. And then generally, the number of meetings should not be stated. So what we mean by that is, you know, in constitutions, I've seen some that have prescribed a minimum of 10 board meetings a year. So that's obviously too high. I mean, they might meet 10 times in a year, but for most years they probably wouldn't. And technically then they're not compliant with the Constitution. Some of the state acts do prescribe a minimum number of committee meetings. So obviously you have to comply with that, and the Constitution has to be consistent with that. The Constitution should authorize the board certain powers. And there's a general power, you know, to be responsible for the organisation, but also there's powers to delegate the board powers. And importantly, there's usually a power to make what's called bylaws or regulations, which support the Constitution. And so your board charter might be considered a bylaw. Okay. So if I can just talk a little bit about bylaws and regulations. So we start with the legislation, and then you've got your Constitution, and then beneath the Constitution are your bylaws or regulations. So it's terminology. I'll call it bylaws. Now, the difference between the Constitution and the bylaws are, if something is important enough that the members should have a say about it, or if the legislation says it has to be in the Constitution, then obviously it should go in the Constitution. Everything else can go in the bylaws. So the more prescriptive things that are subject to more change, these can go in the bylaws, and the bylaws are made and changed by the board. So they don't necessarily have to go to the membership, whereas the Constitution can only be changed by the members passing a special resolution. So we give some examples of bylaws here. How committees are appointed and operated, and by committees we mean, you know, like the committees underneath the board, so subcommittees, policy and budgeting process, levels of authority, etc. Now, when we say not-for-profit organisation, what does that actually mean? It's got nothing to do with whether you make a profit or not, because certainly you do need to make a profit or a surplus. It's all to do with taxation, because not-for-profit organisations have special tax concessions or benefits. So in Australia, it's all about tax. And while it's not defined in the legislation, the ATO does specify 3 things that you need in your constitution in order to qualify for the tax concession. So the first is having an objects clause, which is, you know, it can be for anything other than operating for the profit of the members. The second, and related to not operating for the profit of members, is no distribution. So if you make a profit at the end of the year, you can't pay a dividend or give it back to the membership. And if you wind up the organisation, if there's money left over, it can't go back to the membership. It has to be transferred to another not-for-profit. So these are the 3 things in the Constitution which makes an organisation a not-for-profit organisation. Okay. Any questions coming through, Ash?
Not yet. But I found out that in Victoria, the law doesn't require a minimum number of committee members, while in ACT, an association must have a minimum number of 3 committee members.
Okay. Yeah.
Yeah.
Okay. So now just to recap, the difference between board meetings and general meetings. So board meetings are for directors and general meetings are the formal meeting of the membership. So frequency, board meetings can happen frequently and often at short notice. And general meetings usually only once a year, AGM with 21 days notice required. What can be discussed at a board meeting? Usually anything. Whereas general meetings, only things that are in the notice of meeting should be discussed. So there shouldn't be any surprise matters that come from the floor of, for example, the AGM. And voting. So directors should not be able to give proxies to another director. Alternate directors are not recommended. And importantly, directors have a duty to attend meetings. So right now, the minimum standard of any committee member or board member is that you attend every meeting. And not only that, the attendance, but you have to come prepared. And members, on the other hand, they can choose to attend an AGM or not. And they can appoint a proxy if they can't attend in person. And usually general meetings have more process than board meetings. Okay. All right. So once you've incorporated on some ongoing matters for consideration. So on setup, obviously you need bank accounts and signatories, financial systems. And what we mean by that is a way to process payments or transactions, and it might be setting up of MyOb or Xero. Consider what insurance policies you might need. Keep a register of members. And that might be a part of your membership database. We make the distinction because the register of members, depending on the Act, will have, certain information, but the membership database will have more information than what's required in the register. And you need a membership database, especially if your membership grows, and you need a way to track and manage who is a member, who's renewing, how to send renewals, who are you contacting, and if you, for example, do activities, who's being engaged. And when you're starting out, it's quite common for associations to just use Excel as their membership database. But hopefully, as you get a bit more funds, you can convert to something more sophisticated. So we certainly do not recommend Excel in the long term. And then consider whether you need setting up a website and social media pages. Now, ongoing, you have to hold board meetings. So look, if the organisation is not doing that much, maybe you only need to meet once or twice a year. But certainly there is a duty for the board to meet. And then comply with your reporting requirements, as we mentioned in the previous slides, and any tax obligations that you might have. And then you have to hold an AGM, and then consider ongoing communications with members and stakeholders and delivery of member services. So with around membership, in the next webinar, which is in 2 weeks, it's all about membership. So membership engagement and communication strategies. So we look at structures, retention tips, recruitment tips, and the importance of communications for associations. And then in the 3rd webinar, which is 2 weeks after that, we will look at the role of the board or the committee, and in more detail, the role of the various office bearers, so public officer, president, treasurer, etc., and some of the legal duties and how to run committee meetings and board meetings, etc.